Professora Amina, seu microfone está mudo.
Okay, thank you. I'm gonna start. Okay, good morning, everyone. We are on our second week of the International Winter Course of CEDIN with Konrad Adenauer Stiftung. And we are delighted to introduce one more time Professor Malgosia Fitzmaurice to another subject today. She holds the chair of Public International Law at the Department of Law, Queen Mary University of London. She specializes in international environmental law, the law of treaties, and indigenous people. She publishes widely on these subjects. She has delivered a lecture on the international protection of the environment at the Hague Academy of International Law. Professor Fitzmaurice was invited as a visiting professor to and lectured at various universities such as Berkeley Law School, University of Kobe in Japan, Panthéon Sorbonne. She's editor-in-chief of International Community Law Review Journal and of the book series published by Brill Nijhoff, Queen Mary Studies in International Law. We want to say happy birthday to Professor Malgosia today, so it's even more special because she's spending a few hours of her birthday today with us. So Professor, accept our wishes on behalf of CEDIN, on behalf of Professor Leonardo Neme. Today we're going to talk about the consent to be bound from classical to modern methods. Professor, I pass it on to you. Thank you one more time.
Thank you very much for your such a kind and generous introduction. And again, like yesterday, I am going to use PowerPoints to certain extent, but I am not going again to slavishly follow the text on the PowerPoint, rather as a point of reference to make it easier to follow what I am saying by the participants. So I am going to talk today about a classical area of international law and international and law of treaties, i.e. consent to be bound. So the title of my presentation is Classical to Modern Methods. And I will particularly would like to concentrate on modern methods because this is far more interesting and exciting. However, to be kind of orderly, I will quickly go through the classical methods of consent to be bound. Consent to be bound, obviously, is one of these areas of law of treaties which, although sounds extremely technical, is very important because it has direct and closest link to state sovereignty. Obviously, states express consent to be bound by a treaty as an expression of its sovereignty, which already the Permanent Court of International Justice stated. So the means of consent are supremely important. I will only talk about means of consent which are contained in articles of the BCLT, articles 11 to 17, and not about reservations, which obviously also form part and parcel of consent to be bound, but this is a totally different and huge area. I am very happy to answer any question which will come later on reservation, but we simply don't have time to raise it. But it is far more complex area, consent to be bound, that it's usually perceived. So the classical means of consent to be bound have been developed and evolved through hundreds, thousands of years of state practice, and there is basically no dispute as to classical means of consent to be bound, as they are included in the VCLT 69. So the consent to be bound by a treaty, it's not only the method of a consent, but also who can bind a state. So what are the persons who can bind the state? So this is dealt with in Article 7 in various ways. So Article 7 has the basic provisions on who can bind a state to be bound by a treaty. So first of all, full powers. So we have the mechanism of full powers, and only on this basis, in Article 7(1)(a), a person is considered as representing a state for the purpose of adopting or authenticating the text of a treaty, or for the purpose of expressing consent of a state to be bound by a treaty if he produces appropriate full powers, or B, it appears from the practice of states concerned or from other circumstances that their intention was to consider that person as representing the state for such purposes and to dispense with full powers. However, of course, states are extremely careful to be bound by a treaty. So usually the scenario of Article 7(1)(a) is followed, i.e. there are very precise full powers. And now, in my view, the most fascinating and interesting so-called Article 7(2), the Big Three. So the Big Three are types of person who, by virtue of their functions and without having to produce full powers, are considered as representing their state. A, heads of state, heads of the government and minister for foreign affairs for the purpose of performing all acts relating to the conclusion of the treaty. B, heads of diplomatic missions for the purpose of adopting the text of a treaty between the accrediting state and the state to which they are accredited. C, representative accredited by states to an international conference or to an international organization or one of its organs for the purpose of adopting the text of a treaty in that conference, organization, or organ. So let me go to the Big Three. So the Big Three are these three types of persons who, due to their functions, do not have to present full powers in order to bind a state. As you know, this can lead to several misconceptions and conflicts between states, and there are cases before the International Court of Justice, as well as before the International Tribunal for the Law of the Sea, which actually were based on the conflicting notions on who can bind a state. And such a classical case before the ICJ is Qatar-Bahrain case, and also Cameroon-Nigeria. In these two cases, in the first of these cases, it was the ministers of foreign affairs of Qatar and Bahrain who signed a document which the court said it was a treaty, although it was, they were minutes of the meetings, and the minister of Bahrain claimed that he never thought that he was binding his state by the way of signing the minutes. The court has very strict interpretation relating to Big Three. The court said that on the basis of general international law and general international customary law, ministers of foreign affairs, by the way of their function, can bind a treaty. Even more interesting, in my view, was 2002, the Cameroon-Nigeria case. In that case, the president of Nigeria signed a declaration on territorial dispute, which was considered by Cameroon to be binding exactly on the basis of the provision of the Vienna Convention and customary international law. The defense before the International Court of Justice was based on a premise that, in fact, at the time that this document was signed, the joint declaration, Nigeria was under military rule, and the military council had the highest authority to bind a state by expressing consent to be bound, not the president. I.e., presidential consent to be bound had to be approved by the military council. And then the argument went on that Cameroon, as a neighboring state, should have known about this provision. The court was very short in answering that no state has obligation to be aware of internal law of other states. And as we know, one of the main principles of law of treaties and BCLT is that a state cannot rely on its national law, Article 27 and other articles, 46, I think, of BCLT, and that according to basic rule, the signature, the consent of the bound to be bound expressed by the president binds a state. So we need to remember that the court is very, very strict in following the rule expressed in the BCLT in relation to Big Three. I would like also to mention that there is one case which was before the Permanent Court of International Justice and entered the history under the name of so-called Mr. Elan's Declaration, and it was in 1918, just before the peace talks after the First World War, when Mr. Elan, then Minister of Foreign Affairs of Norway, was talking to the Danish ambassador to Norway and saying that if Denmark will not question the sovereignty of Norway over Spitsbergen, Norway will not question sovereignty of Denmark over Greenland. So again, the PCIJ was of the view that there is no doubt that the statements of the Minister of Foreign Affairs bind a state. So this is what I think important in consent to be bound, who can bind the state, but also show that seemingly very straightforward provisions of the Vienna Convention can actually result in problems, conflicts, which find its solution before the International Court of Justice or other courts. It was also interesting case before the International Tribunal for the Law of the Sea, where between two states, and the question also was who can bind the state. So we need to see that sometimes states try to rely on national law in order to avoid being bound by the document which they are not happy with. So now a bit of history. Historically, the question was before the Vienna Convention in 1920s, 30s, what has supremacy in relation to state to be bound by a treaty, ratification or signature as a means of expression of consent to be bound. Obviously, this belongs to history because we know that all the treaties are extremely precise in saying what constitutes consent to be bound. But if we look through the lens of historical development, there were two main points of view, one expressed by Lord McNair, who was of the view that ratification is the main form of consent to be bound, and other was expressed by Gerald Fitzmaurice, who was of the view that ratification was only necessary if circumstances or intention of the parties indicated such a procedure. So we can say that these days I have never seen a treaty which wouldn't specify in a very detailed way the means of consent to be bound. Its states are very sensitive about it. But if we have to draw a principle, a multilateral treaty usually is subject to ratification, and bilateral treaties of technical nature, of educational nature, can be subject to consent to be bound by means of signature. So now I am coming to. Now I would like to go to Article 11 of the BCLT, which enumerates classical ways of means of consent, of expressing consent to be bound by a treaty. So the consent of a state to be bound by a treaty may be expressed by signature, exchange of instruments constituting a treaty, ratification, acceptance, approval, or accession, or by any other means if so agreed. So what does it mean? It means that Article 11 of the BCLT enumerates all known ways, classical means, methods of consent to be bound. By in the second segment of this article, or by any other means if so agreed, it shows the flexibility of the Vienna Convention and also flexibility of the practice of states, because it means that states are absolutely free to choose a way they want to be bound by a treaty, to express consent to be bound by a treaty, right? So we have classical means, and then absolutely the whole way of methods, and I will talk about it soon, how states can overcome the formalistic approaches to consent to be bound and choose completely different ways to express consent to be bound, methods which are not free of controversies, of course. So, not to spend too much time, a signature, of course, is one of the means of consent to be bound. And we have two types of signature. One, which is just adoption of a treaty, which doesn't mean it doesn't express consent to be bound. And then the consent to be bound, which is expressed by a definite signature. It means it doesn't need any other steps in order to bind a treaty. Now, ratification. Ratification is the most common way of consent, of expression of consent to be bound. And now I would like to just remind ourselves that in Article 2.1, paragraph P, DCLT gives a definition of what is ratification. And ratification is the international act, so named, whereby a state establishes on the international plane its consent to be bound by a treaty. And why I put it here? Because as you can see on this slide, and I noted it not only during my work as an educator, but also reading many publications on the law of treaties, but the most common mistake is to confuse ratification as a means of approval of a treaty internally with ratification, which is an international act. So international act, and this is the ratification which is meant by the Vienna Convention. So for instance, the deposit of the instrument of ratification by a state to a depository, be it Secretary General of a state which is the depository of a treaty, it is ratification. The DCLT is absolutely not concerned with the procedure, internal procedure of approval, domestic approval of a treaty, which commonly is also called ratification, and commonly it's going through parliamentary procedure. But for instance, in the UK, it's the government which ratifies the treaty. There are very few treaties which require parliamentary approval. So this is the point which I would like to specifically highlight. So now acceptance approval is basically a modern way similar to ratification, and it belongs to the same group of consent to be bound. Now, Article 15, accession. Well, accession is simply ways of consent to be bound to states which did not participate in a negotiating procedure. So there is open accession. So any state may become a party to a treaty, but also there are conditional accession that in order for a state to become a party to a treaty, there are certain conditions which have to be fulfilled. For instance, it's often by invitation. For instance, the Helsinki Convention on the Protection of the Baltic Sea Environment has an accession provision, which means that a state can accede to this Helsinki Convention only if it is invited by all the original state parties to the Helsinki Convention, and if it promotes and is interested in environmental protection of the Baltic Sea. So obviously it's a great limitation on which states will be invited, and that was formulated with the view of Norway acceding, which it never did. So this is also doesn't, I think, cause much problems. It's really classical ways of expression of consent to be bound. But now I would like to spend some time, the rest of our lecture today, on the second limb of the Article 11 of the 1969 VCLT, any other means of consent to be bound, if so agreed. So I now explained the first title, part of the title of my lecture, classical methods. And now I will come to modern methods of consent to be bound, which are not included in the VCLT, and they are, I should say, they are originated through practice of states and treaty practice, recent treaty practice in the realm of international environmental law. So the first such a means of consent to be bound is so-called tacit consent or opting out system. So this system of tacit consent or opting out was particularly elaborated in various conventions which were concluded under the auspices of International Maritime Organization. So as we know, IMO sponsored about over 50 conventions, and the most important of them are like SOLAS Convention, the Convention on Protection of Life at Sea, the MARPOL Convention on the protection of pollution of the from ships, and also a London Convention on against dumping and the protocol. So why this, what is the basis of the tacit consent opting out procedure? Well, this procedure is actually less based on consent of the state and more based on the will of an organ of international organization. So we have a switch from a state as a master of a treaty to a more prominent role of an organ of an international organization. So briefly speaking, the main premise on which this tacit acceptance is based is that the organ of the IMO, in that case, it's mostly the Committee on Protection of Marine Environment, takes a decision that certain annexes to convention or a convention has to be quickly amended. So this is the procedure which has in mind the efficacy of amendments to the treaty. And let me explain. It's quite complicated, more complicated than normally it is perceived. So on the example of the MARPOL Convention, MARPOL Convention is a global convention. It's almost 99% of the world commercial tonnage of the commercial fleet are state parties to the convention. So it consists of an umbrella convention of MARPOL, which sets out the main obligation of states, and then it has 6 annexes. And these annexes deal with pollution, prevention of pollution of oil, chemicals, various types of chemicals, and also garbage, sewage, very unromantic, and also the emission of gases, so climate change, basically. So annexes deals with protection of ozone layer and climate change, very important. So it deals with SOx and NOx gases, etc. So we have two types of possible amendment to a treaty or consent of the state for the amendment. Under the DCLT, classical amendment of a treaty relates to consent to be bound and has to go through all the procedures which are expression of consent to be bound. So this kind of amendment, the classical one, is the amendment of the umbrella main convention. But what about the 6 annexes which form the core of the Marpol Convention? We have changing circumstances, we have changing environmental circumstances, we have changing in technology. Amendment to a treaty and adoption of a new expression of consent of a state in this in relation to this aspect may take up to 1 year, 2 years, 3 years. It's a very lengthy procedure. So the question may be asked, are these lengthy procedures of consent to be bound and amendment to a treaty, which is part of the consent to be bound, fit to deal with emergency of protection of the environment and development of science and technology? The answer is no. Therefore, the IMO came out with, developed the procedure of opting out and or tacit consent. So this procedure combines the will of an organization with also sovereignty of a state. So this is very complex. So the environmental committee of the IMO takes a majority of state decision that, let's say, the annex on the oil pollution, and it already happened several times, has to be amended. So consent of states is required. So this kind of decision can be taken by the majority, not usually by it is taken by consent of all the states, but it can be taken by majority. But then what happened next? Is it binding on states? Not yet. States have time to opt out. So therefore, it's called tacit amendment opting out. So in contrast to opting in, then the states have to give express consent to be bound. This is only express opting out. If a state within a certain period of time is not expressing its opting out, then it's bound by the decision. And there is a period, let's say 3 to 9 months of opting out, and then the decision enters into force. So it may happen that a state which did not opt out in time is bound by such a decision. So that already in initial stages of working of Marpol Convention raised objections of states that it encroached on its sovereignty. And now let me express even more. It is one of the areas which I researched very in great detail. Normally, this procedure is dealt nationally in a quick way. So normally it doesn't go through the same very lengthy, drawn-out procedure as consent to be bound by a treaty, amendment to a treaty. However, some states, and I discovered it was Poland, for instance, was not aware exactly how this procedure was working. So it turned out that Poland found itself to be bound by several amendments which it was not prepared to accept, but in the end had to accept it due to international law. So many states, such as Poland now, nevertheless rely on classical methods of consent to be bound and internally go through all the procedures which are related to highest parliamentary approval of such amendments. But the tacit consent is the, so to speak, the first area of consent to be bound, which is not classical and which puts in some way states into position of not sometimes fully expressing its consent to be bound, because the whole procedure is based on a different premise. Now, in my view, the most interesting new procedures of consent to be bound arose on the basis of growth of multilateral environmental agreements. So in 2000, the Churchill and Ulstein published a very important article in American Journal of International Law, which highlighted the phenomenon of these agreements, and both authors call them autonomous institutional arrangement. So why it is called like that? It is called like that because very often the negotiating states drafting international multilateral environmental agreement left out for conferences of the parties or meetings of the parties a very important areas to be filled by the decision of these organs. And I will give the examples. So in general, these COPs and MOPs fill the gaps which were left in relation to a normative content of a treaty. And this is a very important point. So as I say here, that involves a continuing process of lawmaking process due to decision-making of COPs, conferences of the parties. So these conferences of the parties, for instance, they have very incredibly far-reaching functions, like setting priorities, reviewing the implementation of the convention, consolidating and analyzing information from governments, civil society, and also individuals. So we can divide the functions of conferences of the parties into powers of decision of the amendment and modification of convention and adoption of new protocols, decision-making and resolution powers, and supervisory powers, interpretative powers, and powers in respect of the establishment of non-compliance mechanism, which is a very important area, actually the most important area. So this is the gray area of international law, because by law, the decision of COPs and MOPs are non-binding of states. But as Professor Kreber stated in one of his writings, states treat them as binding. So this is a very gray area of international law. So yes, these decisions of COPs, conferences of the parties, also have a gray theoretical area of debate of legitimacy of such decision making. I don't know if I will have time to dwell on it, on legitimacy, but maybe I will borrow 5 minutes just to signal the problems related to legitimacy. So there are, as I already mentioned, various theoretical approaches to this evolving lawmaking procedure of conferences of the parties and meetings of the parties. So first of all, there is a view that these organs are self-standing entities which have to some degree autonomous character. Then Professor Nolte, while he was working on subsequent practice, he called them a hybrid body between a diplomatic conference and an organ of an international organization. So, just a second. So I would also like to say that Professor Brunet calls it de facto legislation. De facto, not de jure legislation. As I already mentioned, the most important area of lawmaking of such organs is non-compliance procedures, which are only done on the basis of so-called enabling clauses. So the treaty says that, like a Montreal Protocol, on the basis of this article, the meeting of the parties will set out non-compliance procedure. And non-compliance procedure, briefly speaking, decide on which states are in non-compliance of the treaty and follow up such a statement by even possibility of suspension of a state in rights of a party to a treaty. So it's a very far-reaching power. So, for instance, the Kyoto Protocol in several articles mention that the meeting of the parties of the Kyoto Protocol will set out all the core flexibility mechanisms which are the basis of the Kyoto Protocol, like the emission trading, for instance, clean development mechanisms, and joint implementation. So all the core mechanisms of the Kyoto Protocol were set out by the decision of the Conference of the Parties. And this prompted also non-compliance procedure under Kyoto to, for instance, Saudi Arabia protesting all the time that such a far-reaching changes in normative lawmaking concerning the treaty should only be done on the basis of express consent of the parties to a treaty based on proper amendment procedure. So we have a question of legitimacy. How do we explain that the conference of the parties and meeting of the parties are given such far-reaching functions as to basically fill gaps in the text of a treaty? And this is the secondary lawmaking, because this is something to states did not consent when they were signing multilateral environmental agreements. There are several examples of this. For instance, in the 1979 Convention on Long-Range Transboundary Air Pollution, it provides that Conference of the Parties can fulfill any other functions as may be appropriate under the provisions of the Convention. So it's basically carte blanche for any decision of the Convention of the Parties. So United Nations Framework Convention of Climate Change states that Conference of the Parties is to exercise such other functions as required for the achievement of the objectives of the Convention. Article 7, paragraph 2. Again, an extremely wide function given to Conference of the Parties, possibly states ratifying the multilateral environmental agreement could not foresee the extent to which decisions of COPs and MOPs will modify their obligations under the treaty without a formal consent to be bound. So I think that this is a fascinating development. Yeah. So the various theories, I already mentioned one, which concern the basis on which decision COPs, MOPs the decisions have binding force. So the use of rules in articles in Kyoto Protocol, then enabling clauses are expression of intention of the parties, and this intention of the parties gives the binding force, and the theories of soft effect or de facto lawmaking expressed by Professor Brunet. So this I think I will pass on. And now maybe I will say that this very far-reaching functions of the COPs, MOPs has given rise to the question of legitimacy of such decisions. So when I studied this question to my book with Professor Mercouris, I came about a statement of Professor Bernstein, who said as follows: legality is potentially violated when a treaty body, group of experts such as scientists empowered by a treaty, or even a representative body of state delegates, makes a decision that appears to go beyond the mandate given to them by the statute to which states consented. So maybe this statement could be somewhat an invitation for a discussion when I shortly finish. How do we approach the question of legitimacy? Is it going beyond? Is it beyond legality, or is it within the confines of what states consented to be bound? Now, the question of legitimacy can also be of decisions of COPs, MOPs, can be also assessed within the paradigm of fairness, fairness as legitimacy, a theory which was the main proponent and the author was Professor Thomas Frank. And he gave quite a lot of parameters of when legitimacy is fairness. So legitimacy, the attributes of legitimacy as fairness has to have symbolic validation, determinacy, adherence, and coherence. And Frank defined determinacy as the ability of a text to convey a clear message, to appear transparent in the sense that can see through the language of law to its essential meaning. So we can look at the decisions of COPS, MOPS, amending, modifying the treaty text, whether they fulfill this paradigm of legitimacy as fairness within the context of theory of Professor Frank. He also said that constancy requires that a rule, whatever its content, be applied uniformly in every similar or applicable instance. So we can look at COPS, MOPS, amending, modifying multilateral environmental agreements through lens of theory of Professor Tom Frank. So they flesh out certain fundamental provisions of multilateral environmental agreements. In my view, it can be said that they formulate general, coherent, and well-determined new rules. And they are sometimes, these rules, applicable in a repeated fashion by states. But is it always the case? I am not so sure. For example, in the case of the International Convention for the Trade in Endangered Species of Animals and Plants, states can make a reservation to a decision. It's a fragmented way in which the decisions of COPS are applied. So again, can we apply theory of Professor Frank to all the, I would say, rule-making of COPS and MOPS? I am again not sure. It's a big question mark. And finally, the theory, the legitimacy of decisions of COPS, MOPS was attempted to be explained by Professors Brunet and Tup, who transferred the theory, interactional theory of Lon Fuller into the area of decision-making of conferences of the parties. This is so-called theory of internal morality of Professor Lon Fuller, and it's based on avoidance of contradiction, generality, and congruence with underlying rules. So what is the core of this theory of interactional theory is that it's not based on formal bindingness or binding character of a decision, but it's rather based on getting into consultations, persuasiveness of the decision making, and requirement that rules be compatible one with another and reasonable, and the official action is congruent with known rules, and that rules are transparent and relatively predictable. So we can see certain link between the transactional, interactional theory of Professor Fuller as transposed on COPS MOPS by Brunet and Tup, certain link to legitimacy as fairness in theory of Professor Tom Frank. So lastly, there is a theory, a procedural theory of legitimacy. Actually, I managed to collect all the theories which relate to decisions of conferences of the parties. I actually studied these problems. It's my ongoing problem, actually, even within the L'Institut de Droit International. So I am very interested in it. So the last theory is procedural theory of self-guiding legitimacy. So this theory is rather practical, and it relies on prior consultation between parties concerned, due process, transparency of proceedings. So this theory sounds quite easy, but even the Dr. Saban-San, who is offered this theory, observed that the concept of legitimacy is very complicated, complex, and consisting of very diverse elements. So she only signaled, highlighted certain procedural requirements for the decisions of conferences and meetings of the parties to be legitimate, but it's still a lot to be done. So I think that I am almost finished with my presentation, and I would like to conclude saying that in my view, the decision of conferences and meetings of the parties are a very fascinating new area of the law of treaties, and that their continuing normative functions are not still fully understood. And although in practice states follow up its decisions, there is still a lot to be researched in relation to their legitimacy and in relation to why actually from a behavioral point of view, why states accept these decisions as binding, although from the purely formalistic point of view, they are not binding. But all the multilateral empowermental agreements, which are mostly general international law treaties, which they are 180, 100 state parties follow these procedures, and they are very active, very much live procedures. So I think it's still quite a lot of, quite a wide field for scholarly research and practical examination. So, obrigado. Thank you very much for your attention.
Thank you, Professor Malgosia. It was very interesting. That's a very exciting argument for me as well. I really like to study the law of the treaties. And especially when it comes to interpretation, I find very interesting the link we can have between the consent to be bound and the evolutionary means of interpretation as well. Yes. I would like to know your opinion about it, because especially like in the jurisprudence of the European Court of Human Rights, we have this evolutionary method of interpretation. How does it conciliate with the consent to be bound by the states?
Yes, it's another point in my view of contention, and states are not often happy with it. So I would like to say that when I researched this evolutionary interpretation, which thank you for bringing it up, of course, we don't have time. It would require several hours to debate. I came to the conclusion that we can distinguish, and I wonder what you think about it, between evolutionary interpretation, which is done by stating and interpreting of a treaty, and particularly evolutionary interpretation, which is followed by the European Court of Human Rights. I think that the practice of European Court of Human Rights is very singular and very special. When we look at the judgment of the ICJ in navigational rights case, It was what, Costa Rica and, what was it? Costa Rica and, well, navigational rights case. The court simply look at the changing circumstances and maybe the clause in the treaty between two states and Nicaragua, Costa Rica and Nicaragua, between two states, which actually gave rise that this generic term of, now you are going to laugh, comercio, probably I pronounced it all incorrectly, Spanish word comercio, was a generic term which could have been interpreted through evolutionary interpretation. But then obviously the question arose, is it evolutionary interpretation or is it subsequent practice? Unresolved in my view again. But when we come to European Court of Human Rights, it all started with trial case in which the court called European Convention a living instrument, which has to be interpreted in light of present day. And then we had already the big opposition of states, and then the British judge, Gerald Fitzmaurice, said that he is not against the evolutionary interpretation, and only if states express the intention of such an interpretation, which he thought was not the case of the European Convention on Human Rights. Well, from then, the court has evolved into an almost philosophical approach, in my view, to European Convention as a common expression of common ethical approach to human rights. Therefore, this common approach has to find its expression in evolutionary interpretation. So I think it's a very special case of evolutionary interpretation. And obviously, we have to take in balance the philosophy underlying human rights, the role of European Court, but also the confidence of states into rule of law. I mean, how far a court on an organ can go in changing the spirit of the convention. I mean, it already started in Golder case, and I hope you agree with me, when the court interpreted one of the rights of the convention as adding a new right completely. And it was the time when a classical lawyer like Sir Ian Sinclair absolutely lambasted the decision of the European Court as mocking consent to be bound. But somehow I think the court is more and more approaching philosophically, evolving the convention through philosophy of human rights. But obviously it's not the only court. Inter-American Court of Human Rights that is doing exactly the same. And in this advisory opinion 2018 of environmental rights, it actually interpreted, I think, Article 26 of the convention as giving many rights which were not there, and even extraterritorial application. So yeah, all courts are doing this, and thank you for bringing it up, because it also, I don't want to use the words, but let's be contentious, erodes to some extent the classical and unmovable principle of consent to be bound.
Yes, I find it extremely interesting. These past days, we had a judge from the Inter-American Human Rights Court. He talked a little bit about it, and then we had other scholars and jurists who has a more positivistic approach to law, to the law of treaties, And there is a big difference between the interpretation we see in the ICJ and in these human rights courts. And it's very interesting to see the extent of the consent to be bound in each mechanism. I will use these arguments that we are talking about to ask your opinion as well about the preparatory works, because there's a lot of divergence in doctrine in order to use the preparatory works to understand like a meaning of a convention. And there are scholars who do not like to use it, because even the convention, the Law of Treaties Convention, it has, I think it wants us to use the words literally, right? And maybe in the preparatory works, we can have another understanding of a treaty. What do you think about it?
Well, I am very skeptical. I mean, Professor Welten, in his work on subsequent practice, he added travaux to subsequent practice. It was quite a novelty, but he said it wasn't, because he said he relied on decisions of international courts and tribunals, which actually look at very often at preparatory work and subsequent within the paradigm of interpretation of treaties. I think that there is no, I think that we have to, in order to answer this question, we need to go to the basic debate of intention of the parties. How far intention of the parties basically belong to the interpretative element of a treaty. Whether we should look at the intention of the parties or not. I don't think there is a clear answer to that. And a very good example is this Qatar-Bahrain case, the second case, in which the court was very skeptical and said that it's not going to look at travaux préparatoires because the Bahrain was saying that travaux préparatoires actually erodes the argument of Qatar on jurisdiction of the court. The court said the travaux is very fragmented and we are not going to take it into consideration. But Judge Weber came to the conclusion that it was totally wrong and relied on several international lawyers like Sir Terence Lauterpacht, who said that intention of the parties is a very important element in interpreting of a treaty. So I really have no view. I think it's a very contentious issue. And although some courts and tribunals take it into account, I think that there is a general suspicion which relates to travaux préparatoires as a political statement, as not really expression of law, but rather political views of state during negotiations to the treaty. So there is some skepticism surrounding travaux préparatoires in relation to ascertaining the text of the treaty.
Okay, thank you, Professor. There is a question from YouTube. Soraya Fontinellis asks, dear Professor, changing a little to the law of the sea, what is your opinion concerning the sea boundaries, treaties, and courts' decisions in face to the sea rise that will de facto change? Some key concepts to delimitation like rocks and low tide elevations.
Well, it's a great question. Only, I have to say I am not an expert at all in this area of delimitation. I can only send to very good articles of Professor Tanaka, who wrote about it a lot. But I am not going to dwell on it because it's this very specialist area of delimitation. And I am not sure that this actually has a lot to do with consent to be bound or the law of treaties. It actually has more to do with conflicts of states like fisheries, for instance. It's the same area of conflicting maritime arguments and conflicting interests, but it really has to do with treaty interpretation. Well, not really clearly with consent to be bound, about which I was talking. So it's more treaty interpretation and conflicting interests of states regarding maritime areas.
Okay, thank you, Professor. I would like to ask you, you talked about the tacit consent. Is the adoption of the treaty itself, no, I mean, I wanted to ask, like, is the publication or the proclamation of a treaty a tacit consent? Can it be understood as another way of consent to be bound?
It is a consent to be bound, and it is included in a treaty, usually. It is included in a treaty. For instance, Welten Convention is also based on consent to be bound, on tacit approval. So this is definitely included in a treaty, and I only brought it up as the way of consent to be bound, not provided by the Vienna Convention on the Law of Treaties, but something which actually developed after like the aviation conventions have it, but really it was developed through IMO conventions and fisheries conventions, yeah, and it really had in mind to be more efficient and to speed up the procedure of the amendment of technical aspects of a treaty. So that's why the annexes to a treaty or appendices to a treaty can be amended through the tacit amendment. So it all originated from the SOLAS Convention, the second SOLAS Convention, which was could not attract enough ratifications. So then IMO decided to include tacit amendment procedure in order to speed up the adoption process. And that was very successful. And after this, all these global conventions like MARPOL Convention started to rely on this procedure. For instance, yesterday I was talking about moratorium on whaling, which was changed in the schedule to the Whaling Convention, and that was also adopted on the basis of tacit acceptance. And what happened? All the states accepted it except Norway, which opted out. So it is totally legitimate.
Okay, thank you. You mentioned the reservations. That's a very interesting topic as well in the law of treaties. Do you have a particular opinion on about when can reservations be made? Because there are scholars who say that they can be made like whenever, if there is a consent between the parties. Or do you think there is a formality and it should be done in a specific moment of treaties formulation?
Well, I think that I agree with the second. I am very formalistic. I think it should be, it's part of consent to be bound and it should be made at this time. And a very good question again, very difficult. Professor Pelé, in his practical guide to treaties, he actually expressly said in one of the provisions that late reservation is invalid reservation. So I think that reservations cannot be made whenever, but should be part of consent to be bound. So when a state signs or ratifies a treaty, should immediately append a reservation. Because this is too easy. Pick and choose. When you think you don't want this provision, you append reservation. I think it's wrong, and I think it erodes relations between states.
Okay, thank you. Is there any questions from the students here with us? If anyone wanna make a direct question. That's a very interesting topic, although we don't study it that much, right? We don't actually, like in graduation or even in postgraduate courses, we don't have this opportunity to spend this time talking about consent to be bound. And it's very, very interesting. So Professor...
I teach Hollier LLM in the law of treaties only. Hollier.
Okay.
It's actually quite popular, and students always think it's in the beginning that it should be very boring. But when they learn state practice the decisions of international courts and tribunals, they think it is really fascinating.
Yes, and they love the case of the first case you talked about who can bind a state, right? That's very interesting. The Nicaragua case, they really like that case. So Professor Malgosia, thank you so much for your availability. We were delighted and very happy to have you with us. Thank you so much.
And thank you so much for having me. I hope it wasn't too boring.
I loved it. It's one of my favorite topics in international law.
Well, I can see that you spent a lot of time in the law of treaties, so it was very nice to debate with you, actually, because to be quite honest, although it is the pillar now of international law, there are very few people like you who really go deep down into the core of the Vienna Convention and the law of treaties. But there is no international lawyer without law of treaties, I think.
Yes, I agree. I had an opportunity to research with Professor Brunt last year on this argument. That was when I got in touch with your works in this matter as well. So it's very, very interesting. It really changed my approach to international law. Studying the law of treaties changed my approach to it. So it's very important.
It's very important. It's like three pillars now of international law. Sources, then, like law of treaties, it's all, and state responsibility is the, bread and butter of international law. And I tell my students, anybody who wants to be a legal advisor or work in foreign office, law of treaties, it's absolute must to follow.
Yes. So that's why we thank you so much for this lecture, and we will remember you during our regular classes on this matter. Thank you so much.
Thank you so much. Thank you. Bye-bye. It was a pleasure. Thank you.
Have a nice day.
Thank you, Professor.
Thank you, everybody. Bye-bye.
Recording stop.